So asking the court to proceed in default and finalize today. Your Honor, I believe the facts will show that this is a hard case, but it's not a complicated one. I know the evidence will show that Mr. Davis is legally blind and gets SSI. So I unfortunately believe this is going to need to be a zero support order. And I believe Mr. Brimhall is going to, in the state will follow Mr. Brimhall's recommendation, and that's going to be for no visitation and asking the court to make a finding of family violence and to order non-disclosure. I believe the evidence will show that a year ago, while Ms. Portis was driving with the child present in the vehicle, Mr. Davis attempted to suffocate her. Probably the other incident she testifies to as well. But anyway, we'll follow Mr. Brimhall's recommendation there and insist on non-disclosure at a minimum.
All right then. Attempted murder may be a little bit past family violence as far as the court's concerned, but I'll go ahead and I definitely need some testimony on that, but I'll go ahead and hear that items opening. Thank you.
Thank you, Judge. Yeah, my recommendation after talking with mom is that this court make her the sole managing conservator of the child. I believe that if there is any room for retro, the child was born in 2016. Some of that predated the time when he was on SSI, but he is currently receiving SSI. So the zero support going forward is it's unfortunate in this case because I think Ms. Portis could definitely use the financial assistance. Regarding visitation, I don't think any visits are appropriate. I think a family violence finding is probably in order. And if he ever decides to get his life back on track, he can certainly file a modification down the road. But I don't think any court-ordered visitation is appropriate at this time. And then, yeah, that's all I have, Judge.
All right, then I'm going to go ahead and swear Miss. Okay, I'm sorry, I was looking at the wrong thing. I'm sorry, Miss Portis moved around on me there. Sorry, I see you now, ma'am. You keep popping around. So there you are. Anyway, I'm gonna go ahead and swear Miss Portis in. Let's get some testimony on that last incident, and I'll confirm, and I'll have her confirm if she knows how long he may be getting SSI. I think I'm gonna have a hard problem ordering anybody to pay out of SSI money, Mr. Brimhall, even though it's he may have gotten this before. He may have not. I need to know if he's been on SSI for the last 4 years. And again, I don't think I could order anybody to pay anything out of SSI directly, and that's the only money he's got. I can always do what judgment is, but it's just going to sit out there unless he gets some real money somewhere. Because I definitely can't order him to pay out of his SSI. So anyway, at this time, I'll go ahead and swear Ms. Portis in and let y'all get this one on the record. Ms. Portis, could you please raise your right hand, ma'am, please? Thank you. Ma'am, do you solemnly swear or affirm the testimony you're going to give here today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, thank you very much. You can put your hand down, ma'am, and then I'll allow Mr. Diamond to start, and then Mr. Brimhall to ask his question and his questioning in behalf of your child, his client. Thank you. You may proceed, Mr. Diamond. Thank you.
Oh, yes. So, Your Honor, I'd first like to begin by offering State's Exhibit 1. I've shown the document to both Mr. Brimhall and Ms. Portis, but that was before it was marked.
All right, I don't have that one. You sent that one to Belinda already?
Yes, Your Honor, but I can share my screen if the court will allow.
Go right ahead, please. Thank you. Sounds like she's bringing it too, so it'll. Okay. All right, I've got it now. You can. The court will know for the record, and Mr. Diamond was displaying State's Exhibit number 1, which is the DNA specimen collection refusal notification affidavit or case information. This is and it's considered to be a chain of custody document. This is the first time I've seen one of these. Anyway, folks, let me go ahead and turn on my video. This seems to be working again. All right, of that document itself, and this is again State's Exhibit number 1. Is there any objection to the court having this information, Mr. Brimhall?
Sorry, Judge, no, I have no objection.
Ms. Portis, any objection?
No, sir.
All right, stage one's admitted. Stage one shows that that Mr. Davis on 3 separate occasions failed to appear to take his DNA paternity analysis in this case on the 30th day of May of this year, on the 30th day of okay, I'm sorry.
I believe it's worse than that, Your Honor. He was in jail. The collector came and he refused. So the
Oh, okay.
jail
So
lieutenant
that's
signed
right.
his refusal.
Okay. So, and I'm sorry, I'm looking at this. Yeah, he did go to collect. He refused to have the DNA specimen collected, and it was witnessed by Lieutenant Martinez, Taylor Gonzalez, and Lieutenant Martinez all signed off on this. So stage one will show that given the opportunity, he failed to do so, and based on the Texas law, that's prima facie. The reason he did it was that he knew the results would show that he was the father of the child in this matter, and the court will so find that he is the biological father. You may proceed. Thank you.
Call Brandy Portis, Your Honor. Ma'am, will you state your full name?
Brandy Portis.
Hey, and who's the child that's subject to this suit?
Anaila Trinity Davis.
Hey, do you expect any more with Mr. Davis?
No.
Okay. Who's the father of Anaila?
Duante Roshan Davis.
Hey, is there any doubt about that? Okay.
I'm sorry, man. Can you repeat that, please?
Me?
Yeah. Is there any doubt he's not the father? That he's
No.
the father? Okay.
No,
thanks.
Okay. And were you able to listen to the statement that I gave the court just a minute ago, Ms. Portis?
Yes.
Anything that I said that needs to be corrected?
Is suffocating the same as choking?
Yes, ma'am. Well, kind of, sort of. I'll let you explain in detail, ma'am. What was? Tell the court what happened then. Thank you.
Okay, so I was driving 75 miles on the highway. My daughter was in the back seat, and he had reached over and began choking me and threatened to. He said he was going to kill me and take my daughter from me, and I ended up leaving him on the side of the road on the highway after I managed to get him out of the car and drove off.
All right. Thank you very much. You may proceed, Mr. Diamond.
Thank you, Your Honor. Have there been other incidents of violence with Mr. Davis?
Yes.
Will you please tell the court?
You got time?
Well, let me ask you this: how many other times has he attempted to choke you?
In the past, we were together for 9 years. It was a long thing. It was a lot. I wasn't prepared for this question.
Well, let me ask you this: more like would you need more than one hand to count them?
Yeah.
Okay. How many other times has he physically struck you?
A lot of times. More than 10.
Okay. Do you have safety concerns?
Go ahead, Mr. Diamond. Okay, that's the final question. Yeah, that's sufficient to show a pattern of family violence as far as the court's concerned. You can go ahead and proceed with the next question then. Thank you. I'm sorry.
Thank you, Your Honor. Am I correct in saying that Mr. Davis is legally blind?
He's legally blind. He can still see, but they said he's got the vision of a 90-year-old man at the eye doctor.
Okay. And I told the court that Social Security is his source of income. Was I correct there?
Yes.
And do you have any expectations that he'll be able to work again?
No.
Okay. Do you believe that he ought to be allowed to visit his child?
As much as I want to say yes, I don't think it's safe. Most of the times that violence occurred was with my daughter present.
Okay. And are you aware of any criminal charges pending against him?
I know he has the possession of controlled substance for what he was in when they did the DNA, when he refused the DNA test. I'm not sure if there's any other pending charges, but I do know of past charges that he was convicted of.
Does he have substance abuse issues?
Yes.
Please tell the court.
The controlled substance was methamphetamine. I believe.
Is methamphetamine his drug of choice?
Yes.
How frequently does he use?
I don't know.
Do you have concerns that he would use around Anaila?
Yes.
Okay. I'll pass a witness, Your Honor.
All right, thank you very much. I'll be back to you. Well, ma'am, I'll be back to you in a moment, but I'll let the ad litem ask you some questions at this time in behalf of his client. You may proceed, Mr. Brimhall. Thank you.
Thank you. Can you hear me, Ms. Portis?
Yes.
All right. Yeah, the state and the judge asked you a good number of questions that I was going to ask you. So I won't repeat the questions. What I'll ask you though is, given all that you've testified to about the violence and his assaults on you, are you requesting that your contact information be withheld from the court order?
Yes.
All right. Now, if he ever does want to get back in touch with you, you're still on good terms and friendly with his mother, is that right?
His mother, yes.
So he can always reach you through his mother?
Probably.
All right. And has he done that? Well, first off, he was released from jail recently, is that right?
Yes. I don't know exactly what day, but she told me yesterday that he was out.
Okay, but he hasn't tried to contact you at all since then, his release?
No.
Okay.
I am worried that he would try to contact me through her, try to contact Anaila through her. You know what I mean?
Okay. All right. Regarding visitation, you already testified, do you think it's not appropriate? Would you like him to be forced to come back and file a motion when he's straightened his life out in order to get that visitation set up in the future?
Yes.
All right. Right now, you don't think he has his life put together in such a way that would be okay to see Anaila?
No.
All right. Regarding conservatorship or custody, as it's sometimes called, are you asking the court to name you as the sole conservator or sole managing conservator of Anaila?
Yes, sir.
Okay. And with him to have no rights and duties, and for you to have all of them exclusively? All right. Regarding support, you heard the state announce that no child support is going to be ordered going forward. Is that your understanding?
Yes.
All right. Regarding the last 4 years, do you know when the SSI started? Was it within the last 4 years?
His SSI started in 2015.
15. Okay. So before the last 4 years. Okay. Has he worked at all? Any other kind of, like, any job? I think you mentioned he'd worked some minor jobs.
I'm sorry. Yes. Before 2015, he was doing surveying, and he tried construction. It didn't work out because he,
Okay. But nothing since the SSI started?
not that I know of. No.
Okay. All right. Well, and then the final element here that we need to have the court address is you and him were both part of a CPS case in Travis County a few years back. Is that right?
Yes.
All right. And the judge down there in Travis County, after you'd completed everything that CPS had asked, dismissed the entire case. Is that right?
Yes.
All right. And that judge, that was in the 261st District Court in Travis County, and the case was dismissed in June of 21.
Okay, thank you.
And I can certainly send over the dismissal order if the court would like.
That's not necessary.
Okay. All right. I have no other questions, Judge.
All right, Ms. Portis, I'm looking at granting everything the state has license request. I'm going to find that first off, that the family violence in this case is beyond the pale. It's just totally inappropriate. Ma'am, has he ever been diagnosed with any mental issues that you know of?
Well, he had called when he was in Lampasas County to talk to Anaila, and he or when he got out of Lampasas County, and he mentioned that he had seen a counselor while he was in Lampasas County, and they diagnosed him, he said, with borderline personality disorder.
Okay,
But-
well, ma'am, that's his testimony that he said it counts. So I'll take it for granted that he wasn't lying to you on that one. All right.
Yeah.
So,
Yeah, it definitely provided some explanations.
all right, then. Well, again, that's definitely a serious one. So I'm definitely looking to name you sole managing conservator. Looking at ordering no court-ordered visitation at this time between him and you. I'm gonna name him a possessory conservator, but this time I'm not gonna give him any rights in a possessory conservatorship until further order of this court. I'm going to go ahead and find that obviously that he's on SSI. He's been on SSI for the 4 years prior to the filing. So the court can't order any retro based on that, and I cannot order any child support going forward based on Texas family code statutes. So unfortunately, I got to order 0 child support, but I'm not going to, based on his own admission that he is least, I'm sorry, has that borderline diagnosis. I'm going to go, and the fact that he's committed these acts of family violence, including choking, which is the most serious one based on all the studies that have been done and information that's been provided me over the years through various educational opportunities, as far as, in other words, continuing legal education. Choking is the worst. So I'm going to go ahead and find that no visitation is appropriate at this time until further order of the court. And that would give him the opportunity to file the necessary paperwork to come back in here and then prove and give the court something showing that he's mentally stable enough to have visitation going for us, or some rights under the conservatorship rights that are granted under the Texas Family Code. I'm going to go ahead and can't order him to pay court costs, so I'm going to waive court costs at this time. And again, no visitation till further order of this court. Is there anything else I need to specifically rule on at this time, Mr. Diamond?
Your Honor, was there a ruling on non-disclosure?
Or not? Yeah, I'm sorry, non-disclosure. I thought with all that other stuff, yeah, non-disclosure is definitely granted until further order of the court. Ma'am, in other words, you can do what you want on this one as far as allowing him telephone or video access or anything like that. But I'm not even going. I'm not giving him any rights whatsoever until further of the court, based on his past history of at least 10+ episodes of family violence, and one which included choking. So yes, ma'am. So anything else, Mr. Diamond?
No, Your Honor.
All right, Mr. Brimhall, anything else?
I don't have anything else. I just wish the court were, I wish the law would allow the court to order support, but I understand that the law is what it is. So
Yeah, 10 years ago, I could order people to pay money out of their SSI, not anymore. Sorry.
yeah, I know.
Ask the Texas State Legislature. They're the one that changed that rule on me. Okay.
Maybe yeah, that would be a good modification to the code, because in this kind of case, I think it's
They changed it on that one, on that and on prisoners, because I couldn't order. I used to order them to pay child support, because they
right.
don't accept voluntary. So anyway, we are where we are, and court will so order at this point. Is there anything else though?
No, nothing, Judge. Nothing legally. I just think
All
it's a
right,
sad case. I wish it were better.
I hate leaving an unsupported child out there, but these are the circumstances legally have to deal with. And ma'am, Ms. Portis, good luck to you, both you and your child. And I wish there was more I can do for you, ma'am. You have any questions, ma'am?
Yes. Do you have any recommendations over what I could do moving forward with the domestic violence part of it?
Ma'am, if anybody commits any type of violence against you, you need to file a criminal charge and stick to it. If there's anything, I'll tell you what, it's still in the best interest of the child that you're protected going forward, because you're the sole managing conservator. I will have Mr. Brimhall talk to you about those items. And Mr. Brimhall, here's the deal. If he's done an act of family violence sometime this year, based on the fact that you're the child's ad litem and mom's the only thing this child has going forward, I will authorize you at the court's expense to file a. I'm sorry, I don't want to put you in conflict.
I can tell her about how to file a police report and that kind of thing.
I'm talking about protective order. So, ma'am, has there been an incident in the last anytime this year of family violence against you?
This year, No, no.
Within the last,
Last year was when the choking happened.
what date?
It was in early August.
Okay.
I can-
Is Mr. Glass still present?
He is. It looks like he's logged on.
Yeah, no, I'm here, Judge.
All right, Mr. Glass, I'm looking at appointing you an amicus in this matter to do research to see whether or not it's too late to give Miss Portis a protective order in this matter. Okay?
Yes, sir.
All right, Mr. Portis, I just gave you a lawyer, and that's Mr. Kurt Glass here. He's going to check into whether or not he can get you what's called a protective order. Because again, if we can get you that, if he shows up on your with a protective order versus a restraining order injunction, if he actually shows up on your front doorstep, you can have him arrested. And it tells him where he can't go. And if he violates it in any manner, way, shape, or form, he can get 6 months. He gets 6 months in jail for that criminally, and then you can file a motion to hold him in contempt and give him another 6 months. Okay. So again, based on this gentleman's circumstance and his criminal history and his drug use and everything else, I'm gonna go ahead and report Mr. Glass to contact you, and I'll allow you to talk to him in the breakout room in a moment to see about getting you a protective order to protect you personally, ma'am. Okay.
Thank you.
And that way, Mr. Brimhall, I don't have to do any, there's no conflict of interest whatsoever, all right? All right,
Judge, could I get a cause number real quick?
all right,
please?
well, in this case, it's just the one I just named was sole MC. It's 22 DFAM, 334,415. But to my understanding, there's not been a protective order filed anywhere else before county, a magistrate or district courts, and technically, I think under this case, technically, if you want to file it, you can file it in my court going forward, sir. And I would set it for a hybrid docket as far as the final, or you can go to a district court as you see fit.
Did you want to make this a temp then, so we could come back?
No, it's totally separate. The protective order is totally separate anyway. It doesn't need to be in there, so we don't have to come back on this. All right.
Your Honor, may I ask?
Yes, sir.
May I ask Ms. Portis for permission to share contact info with Mr. Glass in case there's an issue today?
That's fine.
Thank you.
Can you do my email though?
Yeah, the email, phone numbers, that sort of thing. So Mr. Glass will be in contact. And again, Mr. Glass, you can file, it needs to be filed as a totally separate cause of action, not based on the SAPSR we did here today. And like I say, you can do it in this file and I'll hear it, or you probably need to do it in under this cause number. But it's in the 420, either the 426 can hear it and I can hear it, and I'll contact the 426 judge to give him a heads up in case it's ended up there. Okay.
Yes, sir.
All right. Thank you very much.
Thank you.
Your Honor, I'm sorry. I have one more question.
Yes, sir.
So do you want would the court like the order in this final order? Should it mention that Mr. Glass is appointed as an amicus, or should we draft something separate for that?
You go ahead and put it in this one that he's been appointed to an amicus, but he's going to talk, but to do a totally separate filing. Okay.
Yes, Your Honor.
All right. The court is finding that family violence is such is so acute in this matter that the court finds it necessary to do that. All right. Thank everybody very much. And is there anything else, Mr. Diamond?
No, Your Honor.
Anything else, Mr. Brimhall?
So do you want me released 30 days after this order, or do you?
Yeah, 30 days after I sign the order as far as your representation of the child is concerned. Yes, sir, Mr. Brimhall.
Okay. All right. Perfect. All right. Yeah, I wish we could do more.
Okay.
But
I tell you what, Mr. Brimhall, I'm going to leave you on this one because you may have to come in and okay everything as far as the child. I'll leave you on his ad litem and until Mr. Glass says Mr. Glass files something, then you're still on it. If Mr. Glass does not can't file anything because it's too late, then you're dismissed 30 days after I sign it. But I may need you to appear before the 426 and also approve as ad litem for the child that it's in the best interest of the child that the mom had the protective order. Okay.
okay. Yeah, that's fine. So yeah, I'll just be in contact with Kurt.
All right. Good enough. Thank you. All right. Thank y'all all very much. And we're off the record. And is Ms. Portis free to go?
Well, no, Your Honor, if it's all right, I'll put her in a breakout room, and then maybe Mr. Glass can visit with her when he's ready.
All right. Good enough. Thank you. All right, thank you. Good luck, Ms. Portis, and I'll see you or the district judge in the 426 will see you, okay?
Thank you.
All right, yeah, we're gonna try. It's only a piece of paper, ma'am, and people walk through pieces of paper every time, but at least it's the best piece of paper we can offer you, all right?
Thank you. I
All right. Okay, no problem, ma'am. We're off the record.